notice of appearance? All rise. Justice of the Appellate Division, Supreme Court First Department. PE, the officers having business with the Appellate Division. Your here, your attendance, and you shall be heard.
Good afternoon, everyone. Welcome to the Appellate Division, First Department. We have some 7 hours of argument time that has been requested for this afternoon. So please keep that in mind as I call the calendar. Remember that we have your briefs, we have the record, and we are fully familiar with the facts of the cases. First case is People versus Komaka Odua. Submitted. De La Cruz versus Evers Marina. Five, 1, and 5, thank you. People versus Elaine Littlejohn. Submitted. Gants versus Floorman. 5 and 5, thank you. Horn versus Nestor. 5 and 5, thank you. People versus Frank Brown. Submitted. United Hay versus Harunian. Questions? Thank you. We'll take submission. Padilla versus LeBeau.
Count 7 and 2, please.
Seven and 2 and 6 and 1. People versus Jonathan De Leon. Seven, 2, and 7. Scottsdale Insurance versus Mount Holly.
5 and 1.
Did you give me a time? I heard Scott. Five and 1. 5 and 4. People versus Malik Jones. 5, 2, and 5. Condor Capital versus Cal's Investors. 5 and 2 and 5. Core versus MIP One Wall. 2010 Powell versus New York State Division of Housing. 5, 2, and 5. Burson Properties versus Nomura Credit. 5, 2, and 5. Radio Drama versus Key is submitted. De La Cruz versus Evers Marina.
Good afternoon, Your Honor. Your Honors. My name is Catherine Everett. I'm from the law firm of Cipriani and Werner, and I represent the defendant, Charles Evers, doing business as Evers Marina and Seaplane Base. This matter arises out of a...
We know the facts.
So I'm here today to dispute the dismissal of our motion to dismiss and on grounds of the failure to state a cause of action and the failure of proper service.
Sorry, counsel. Given that we don't know the metes and bounds of the marina, it's a pleading motion. Doesn't the allegation that it took place on the premises of the marina, isn't that sufficient?
I don't believe so, Your Honor, because as the papers state, this was on navigable waters that are not owned by the marina. They had no...
You say in your brief frequently that it's up to the mean high water mark, and it seems like marinas, they have docks that come out, and there are boats that are moored out in front of a marina. So
But this was not anywhere near that, and the photographs show that. And even
there was a photograph
on,
taken by your client, Mr. Evers, right? Was there another photograph?
Unfortunately, the photographs taken by the United States Coast Guard and the New York City Police Department were not clear. However, review of the reports and investigation from that night show that they were using the marina as a reference point because it was on the shore ahead and not because the accident happened as part of the marina.
Doesn't that still leave questions of fact open as opposed to creating a conclusive, undisputed fact? I mean,
going back to, they don't own the water. It was definitely out on the water that this occurred and far away from.
But the question was also whether her trajectory began at the marina, which negligently permitted that to happen.
So speaking to that, the only person that's ever made those averred that has been counsel. In the complaint, which is not verified by the complaint doesn't say it, neither complaints say it. It's only in, and there's no affidavit of merit with the motion to amend by the plaintiff that actually says that A, she left from our marina, and B, that she left after sunset.
Was it argued to the court below that there was no affidavit of merit annexed to the motion to amend the complaint?
Yes, that was argued.
Anything else?
There was no affidavit of merit, and also the service was improper in that they failed to, they served someone that did not have authority to be served, and there wasn't a secondary mailing required under the CPLR 308.
Yeah, but what was the prejudice to that, really? I mean, counsel exchanged information about the case. I mean, it seems like your client was on notice, so that seems like not your strongest argument.
No, I would not say it's my strongest argument. It is an argument, though.
I mean, at this case, it's whether they state a cause of action. While you might be successful, I mean, the question is whether they've stated a cause of action.
However, they don't meet They don't ever state that she left from our marina. She was joyriding. She was in violation of the law when this happened. That no one contests. So she should not be allowed to create a duty by her own violation of a law. There has been no establishment that my client promoted them to leave that day, that there was alcohol involved, all the things that they're saying that my client did in an effort to somehow establish a duty and proximate cause, which don't exist in this case.
But counsel, these are all evidentiary matters that you are addressing. We're just looking at the pleadings. That's all we're doing on the 3211A7, because certainly the complaint alleged that the defendant was negligent in failing to lock the marina gates, which allowed the watercraft to launch from his pier after dark. What else was needed?
But there is no establishment in the pleadings that she left from our dock or that she left after sunset.
Counsel, this is not a summary judgment motion. This is a motion on the pleadings, and she certainly pled that.
Yeah. And I want to add, additionally, also, a cause of action for navigation law, 73A1E, defendant promoted the launching of a personal watercraft from Evans Marina after sunset. Defendant promoted a party atmosphere, which included but not limited to alcohol consumption. What else is needed?
For her to actually plead that she left from our marina, that there was alcohol involved.
Thank you, counsel.
Good afternoon, Your Honors. Brian Isaac. I represent the plaintiff respondent.
Counsel, what evidence is there that they left from the marina? I mean, it's not your jet, not their client's jet skis, that they left from the marina, that they went through that area, that, you know, what evidence is there for any of that?
So, Judge Renwick, if you look at the complaint, it's page 165 to, just 165, 33 to 38. The claim is that that the marina failed to properly keep the premises locked, failed to properly secure the premises, failed to enforce navigation law. I'll get to that in a second.
So there's a gate with a lock, and these people, because it was unlocked, decided, because a gate without a lock doesn't mean it's wide open. They decided to open it up and go right in, and
right.
That's the basis of, how old are these people?
They're not minors, but there's also a...
They're adults.
Right, there are, but there's a New
But
York...
is there anywhere in the complaint, I'm sorry to interrupt, just one last part, saying that they actually left from the marina on the jet ski? It seems like your opponent hammers that point home very effectively.
She does, except look at 79, 172 of the record. That on or about August 28, 2018, the plaintiff, Yoquero de la Cruz, was lawfully upon the aforesaid premises. So now you have a claim that she was on the premises.
Well, but that could also mean she was out in her jet ski in front of the marina. It doesn't say I left from the marina.
Well, it doesn't say from the marina. If it was there, I would say it, but lawfully on the premises is the marina. And as you know from reading our brief, when the defendant relies on the Coast Guard and the police report, those things are ambiguous because sometimes they say that the accident happened on the marina. Sometimes they say VO, vicinity of the arena. Sometimes they say outside of the marina, I'm sorry, and sometimes they say in the marina. So my point isn't that I have a 240 sub 1 labor law case or a rear end collision case. It's a 3211 motion. When my adversary says to you, I haven't proven anything, I don't have to prove anything. It's a pleadings motion. Really, it's not only a 3211A7 motion, I believe it's a...
Except that if your claim is that the negligence was the opening of the gate or allowing people to leave after sunset, then it seems to me she would have to debark or leave from the marina.
Well, it
You
also...
have another theory, I know, which is that the marina's premises extended out to the place where the accident happened.
Correct.
And that seems more plausible to me.
Right, and also promoting the event. It's not like we made this up out of whole cloth. We don't have any discovery, but if you look at 146 to 148 of the record, there's actually a New York Times article in which Mr. Evers is actually quoted as saying he knows about this, and he's not enforcing he had an unlocked gate. It's difficult to enforce because he wants to keep the place open. I get that sometimes being a premises owner can be difficult, but one of the burdens that you have as a premises owner is that if you know that a dangerous activity or potentially dangerous activity is occurring, you have a duty to take some measure to ameliorate it. Let's assume that people were shooting off firecrackers or were selling drugs. The fact that you wanted to keep the marina open doesn't satisfy a standard of care as a matter of law. And again, there may very well be proof which would enable the defendant to secure summary judgment, but this is a 3211A7 motion, and I think there's enough there to survive this motion to dismiss. One other point, and I'll sit down.
Counsel, does it make any difference to your position on this motion that the complaint was verified by counsel and that there's no affidavit by plaintiff?
No, it doesn't, because I'm entitled to rely on the four corners of the pleading, and that was their motion, so I don't have to verify anything. I could if I wanted to, but I don't have to. And I also don't think on a 3211A7 motion, despite the basis Yalfa case that this court decided, I think it was Judge Renwick's decision, I still don't think you can convert a 3211 motion into what's substantively a summary judgment motion. One last point, and I'll sit down. The trial court's citation to the 306B decision, the Panisi decision, is directly on point. The facts here are identical. I don't think the trial court abused its discretion in not dismissing the case and granting leave under 306B. There's nothing else. I'll sit down and let my adversary talk to you. Thanks for listening to me.
Just one quick point. In the motion to amend, which adds the promotion claims, they did not include an affidavit of merit with that as well. So again, these are all counsel arguments and
Counsel,
nothing.
since it's a 3211 motion, why does that matter?
I'm sorry?
Since we're just dealing with the face of the pleadings, why does that matter?
Because this was in their motion to amend the complaint, which is part of the same decision that was also appealed from.
Thank you. Thank you both.
Thank you.
Gants versus Floorman.
Members of the court, good afternoon. Howard Essner from Essner & Coben LLP for plaintiffs' appellants. I'll keep it brief today. I'd just like to address 2 points raised by the defendants, respondents in their brief. First and foremost, the underlying motion was not granted on default. The court's order dismissing the case states that after argument via Teams and for the reasons stated on the record, defendant's motion pursuant to 3042D seeking to dismiss the complaint based on plaintiff's willful failure to provide demanded discovery is granted. The record itself—
Putting that aside, substantively, what possible excuse have you ever presented for why this case shouldn't be dismissed for failure to provide discovery? You had time after time after time to produce, and it wasn't produced. Why wasn't it within the court's discretion at that point to dismiss it?
Well, Your Honor, it was produced. The motion itself was made pursuant to 3042, which is a bill of particulars motion. Bills of particulars as to each defendant, specific with detailed allegations and fully responsive to defendant's demands, had been provided. With respect to the discovery which remained outstanding as of the date of the motion, as I detailed on the record, it consisted of a few respectfully non-essential items.
Why is it up to you to decide what's non-essential? If you were ordered by the court to provide it, and you didn't provide it, which you seem to have just acknowledged, why isn't that enough? Why does the court have to decide, let you decide which is essential and what isn't?
And may I add that the court also gave you an opportunity to produce to the court everything that you claim you provided to the defendant in order for the court to be able to decide whether or not your submissions, your discovery production was sufficient, and you failed to do that.
Well, addressing both points, I was not stating, substituting my judgment for the court's as to what was essential or not. However, the underlying premise of the motion was that the defendants were somehow hamstringed or prejudiced in their defense of the case. And respectfully, that was just not true. They had substantially all of the discovery they had requested, and they were—
But Again, you're doing it by saying substantially. You're still substituting your judgment for that of the court. The court told you to produce everything. You're saying it was good enough to produce substantially. Why can't the court say, no, that's not enough? You were told to produce it and you didn't.
Well,
Why is that? It seems to me that you are, again, even in your response to my colleague's question, substituting your judgment for that of the court about what's necessary to do to comply.
no, Your Honor, respectfully, I'm not submitting or substituting my own judgment based on the case law, based on court procedure. To dismiss a case, a meritorious case, based on a few items of discovery that were outstanding is not the common practice. There's a
After the 8th or 9th attempt?
Not correct, Your Honor. And in fact, the court's preliminary conference order made it clear that no motions pursuant to 3126 to dismiss would not be entertained. The preliminary conference order is clear on that. So I agree that there were some items outstanding. I just believe the court acted improvidently in dismissing a case just because there were a few items of discovery outstanding, which
Counsel,
in
there
no
were
way...
4 orders that were not complied with. And at the time of the hearing, you had the tax returns, you had the social media account passwords, you had particularized bill of particulars, and authorizations that still remained outstanding.
Well, Your Honor, particularized bills of particulars had been provided, medical record authorizations had been provided, and notwithstanding the number of court orders, there was never any willful, purposeful disregard of a court order.
So that remains to be seen. Anyway, thank you, counsel.
Thank you, Your Honor.
Good afternoon, Your Honors. My name is Elliot Zucker from Aronson, Rappaport, Feinstein, and Deutsch on behalf of the defendants' respondents. Let me begin by just addressing the preliminary conference order that, for some reason that no one can explain, crossed out the section with regard to 3126 relief. We don't know why that was removed, but to suggest to the court that by crossing that out, that meant any kind of discovery abuse would be tolerated and the defendants or any party would be foreclosed from seeking the appropriate relief, just to me seems to fly in the face of common sense. I also obviously disagree with the fact that this was not a motion granted on default. I think it clearly was. The judge said to the plaintiff's counsel, do you have opposition? And he said no. And yes, there was obviously some debate on the record with regard to the relief we were requesting, but look at the record. There's no opposition. There's a transcript of the argument, but nothing was submitted. And I think the court from the questioning clearly understands our position with regard to what discovery was missing. Again, this was not even the first motion to dismiss we had made. Okay, this had been going on for quite some time. And while I understand that COVID was happening and everything like that, there's no reason a year and a half after our case began, we should still be trying to seek particularized bills of particulars as to the individual defendants. If there's no questions.
Thank you.
Thank you.
Thank you both. Horn versus Nestor. You may begin.
Thank you, Your Honor. Good afternoon, Your Honor. May it please the court, Jeremy Doberman appearing for the first time on behalf of Mary Ann Nestor, the appellant, a senior citizen who will lose her home if the judgment of foreclosure and sale is confirmed.
This was a commercial property.
Your Honor, it's not. In fact,
it was described in the documents as a commercial property. She agreed that it would be used as a commercial property, and now you're telling us that we should treat her like a homeowner. How can we reconcile that where she signed documents saying that this would not be used residentially?
Your Honor, I have seen cases where lenders have abused borrowers and they have, in fact, given loans, asked them to sign documents.
But she signed it. You're not claiming that there was any duress or any...
Correct. I'm not claiming duress or coercion in signing the documents, and I think
But it
that-
sounds like you want us to rewrite the whole thing. In
Well, Your
terms
Honor-
of the amount of the interest, in terms of the fact that it wasn't, she didn't use it commercial, she used it commercially, she used it residentially. I mean, we can't rewrite this written document that doesn't seem to be ambiguous.
No, Your Honor, that's not what we're saying, and there are two prongs to the argument. The first argument is regarding calculation of interest, but I want to focus, because the court's question seems to be going towards this, on the second argument, which relates to CPLR 3408 and the entitlement to a settlement conference. The court is, of course, correct that that generally
But we weren't
applies.
even getting to that. You were asking us to look at this case from the point of view of she's going to lose her home. But there's nothing in the record to support that.
Your Honor, my client informs me that, in fact, she's lived in this property since 1977. Now, she was, of course, pro se when she filed the appellant's brief and the reply brief, so I can't account for exactly what has been briefed so far, but I certainly can raise the issues. So CPLR 3408 was discussed. The CPLR 3408 issue is that the borrower is entitled to a settlement conference where it relates to a home loan. The definition of home loan is not one from CPLR 3408. It's imported from RPAPL 1304, and it relates to situations where the borrower is a natural person, and one of the criteria is that the debt is primarily for personal, family, or household purposes. Now, that word primarily
Was that asserted anywhere in the answer? I'm looking through it and don't see that.
Your Honor, the answer to the complaint you're referring to?
That's the answer I'm talking about.
Okay, no, the answer to the complaint does not contain, there's no defense related to CPLR 3408. CPLR 3408 is a procedural requirement the
Right,
legislature
but is
put
there
in.
anywhere that she swears that she lives there? Anything in the record where she swears that she lives there?
Yes, Your Honor, I believe there is. I don't think it was raised on the judgment of foreclosure and sale motion, but it was certainly litigated in
In the record in front of us, is there any record, is there any sworn statement by her that she lives there?
Your Honor, I don't believe it's in the record. There is, of course, a brief where she indicates that this is exactly correct, both
Counsel, that was rejected on the summary judgment motion, right? The argument that it was residential. So is that correct?
Your Honor,
And so therefore,
I don't believe it
and
was.
was that appealed? Was that decision appealed?
That decision was not appealed, but, Your Honor, I don't believe it was. What I think the court held was that she was estopped, my client was estopped from making that argument by the estoppel certificate that was signed at the time that the note was signed. I think anything else that the court may have found or may have talked about was dicta, and in fact, there was no hearing held to verify any of those facts. I don't know how the court could have found that. The reality is that I think—
Isn't that law of the case, though, at this point? I mean, aren't you stuck with that? You didn't appeal it.
I agree, Your
She
Honor,
didn't
that
appeal it.
it's law of the case that she's not entitled to raise affirmative defenses and counterclaims regarding that. However, that does not mean that she's not entitled to a settlement conference. The requirement to conduct a settlement conference is a requirement that's incumbent upon the courts. It's a procedural requirement. It's a requirement that was put in place by the legislature to make sure nobody is displaced.
You're only entitled to that if she lives there, and there's nothing in the record before us that shows that she lives. There's nothing, no sworn statement by her that shows that she lives there. So how can we conclude that she's entitled to a settlement conference?
Your Honor, that's not exactly correct. RPAPL 1304 allows, or one of the criteria is that it is intended to be or will be occupied by the borrower as her principal
But
residence.
there's nothing,
That's a fact
okay,
question.
so where in the record does it show that she either lives there or intended to live there? I don't see it.
Your Honor, I don't believe it was raised on the judgment of foreclosure and sale, but I believe it was raised previously. And the issue is that the court, I think, when this issue is raised, has a duty to have a hearing on whether or not the— Your Honor, may I finish my sentence?
You can finish, yes.
On whether or not the borrower is actually residing in the property, ever had an intention to reside in the property, and the debt was incurred for personal or family or household purposes. Thank you.
Thank you.
Good afternoon, Your Honors. I apologize. Robert Wolf of Tartar, Krinsky, and Drogan for the plaintiff respondent, Stephen Horn. In granting the summary judgment order in this case, the lower court explicitly relied upon the estoppel certificate that the appellant signed as she admits, in the presence of her own counsel at that time, in which she certified before a notary, she swore it, that this was not her principal residence, that she was using this property for commercial purposes and for investment purposes. She never appealed from Justice Bluth's decision. And Your Honor is correct. 1304 of the RPAPL has as one of its explicit requirements for a mandatory settlement conference that the property at issue be the principal residence of the borrower. It clearly was not. This was not even raised as an issue in opposition to our motion for judgment of foreclosure. The only thing, and the appellant was represented by counsel at the time, her counsel at that time put in opposition to our motion, nothing about her residence, only questioned the inclusion of certain items in the amount to be included in the judgment of foreclosure. And therefore, the raising of this issue on this appeal, I think, is totally improper. I'd like to also point out that 2 weeks ago, January 4, this foreclosure action became 10 years old. The appellant has persistently inundated the lower courts with motions, with refusals to comply with the lower court's order compelling her to appear for a deposition.
Counsel, there was no point when your client was not as timely as they might have been?
I'm sorry, Your Honor.
There was no point when that delay could be attributable at all to your client? Was there any time when the duration of the proceeding could be attributable to your client instead of to Ms. Nestor?
There was a time when we asked the appellant to stipulate with us to an extension of the time to confirm the referee's report because of certain other issues in other litigation affecting the property. And at one point she agreed and stipulated with us, when she still was represented by counsel, to extend that time. It was extended further, but I would point out that when it was in the midst of it being extended, the moratorium by reason of the COVID-19 pandemic set in. And there were other things that the appellant did that prolonged this foreclosure. Her prior counsel withdrew from the case. She was given, I believe it was 90 days within which to find new counsel. She did not at that time, but before that 90 days expired, she went ahead and filed a hardship declaration under the emergency COVID-19 statutes that were in effect at the time. But of course, that hardship declaration was predicated on her assertion that this was her primary residence, which was already decided against her.
Thank you. Thank you both.
Thank you very much, Your Honors.
Padilla versus LeBeau? LeBeau? I'm sorry, did I? Yes, Padilla versus LeBeau.
People versus Brown.
No, submitted.
No, they.
Counsel?
May it please the court, good afternoon, Your Honors. Christopher Della Carpini for the appellant, Mr. Padilla. Justice Kelly dismissed Mr. Padilla's claims after finding that whatever departures Dr. Buick may have committed in her reading of the pathology slides or reporting on it, there was supposedly no issue of fact as to whether her report was even a proximate cause of Dr. LeBeau's decision to undertake ultimately needless pancreas surgery. But in fact, Mr. Padilla's expert pathologist explained that this qualifying language in Dr. Buick's report, which Justice Kelly had cited in finding against Mr. Padilla, that qualifying language was in fact a departure in and of itself, separate from the departure in the reading of the pathology slides. And the expert stepped through the chronology that's well documented in the chart to show how this error in the reporting was at least a substantial factor in the decision to operate. Now, as to the question of this
How do you deal with the fact that Dr. LeBeau at his deposition stated that he did not make his decision based on the report.
Let's look at what Dr. LeBeau did actually say. I have that, I believe it is page 813 of the record. Question, what did you conclude from reading this report? Answer, obviously I read the whole report. The job of the pathologist is to alert of an abnormality that they see. And my integration of this, it was not 100% clear, yay or nay, as far as pancreas cancer. That I think
How does that establish that he relied on it?
he is integrating it into his analysis.
I'm sorry, I'll let you continue, but you're saying he integrated, but in plain language, what he said when he explained that was that what he didn't mention was any excess cells. He didn't say that he relied on any of that. What he said was he talked about the chronic pancreatitis. I mean, he articulated specific things, and one of them was not the excess of cells. So even when you talk about integration, he does not specifically indicate that there was anything with regard to the excess of cells.
I don't think he has to raise an issue of fact.
Even though he articulated specifics in addition to that?
No, he says he integrated the report. He doesn't have to come in and say, oh, this particular word she used, yes, that's what I used.
Well, he doesn't say that. What I'm saying is he lists a number of things, and that wasn't one of them.
That's true, but he does integrate the entire report, and unless he comes in and says, no, I completely disregarded that report, that would refute the issue of fact. But as long as he's saying he's integrating the entire report and he's not eliminating this language that we've identified as a departure, there is at least an issue of fact in his own testimony. But even if he gainsay that, even if he came in and said, no, that had nothing to do with my decision to operate, he's got his own chart that effectively testifies against him. And let's look at that. September 28, 2016, the first day he sees Mr. Padilla, he's reviewed the history, he's seen the concerns, and his concern is, we'll contact him, we'll recommend a biopsy and contact after the tumor board. He's not thinking about surgery at that point. That's page 4878 of the record. October 4th, the next week, the tumor board agrees with him. We're going to wait for the results of the biopsy. It's page 4882 of the record. October 31st, there's an abdominal MRI. The conclusion, malignancy is considered unlikely. We still have no empirical evidence of cancer. November 2nd, 2016, Dr. LeBeau sees Mr. Padilla again. His conclusion, we'll await path results and likely follow up in 4 to 6 months. It's page 1065 of the record. November 8th, 2016, the day Dr. Buick finally signs the report. The tumor board, however, clearly has not yet seen the report because what they write on that day is, path pending, review imaging, and discuss plan of care. The very next day, November 9th, 2016, Dr. LeBeau writes in his notes, path suggestive of possible acinar cell carcinoma. He's read the report, and he continues, the case was presented at our multidisciplinary conference, and consensus was to proceed with surgical resection. That is page 1017 to 18 of the record. Mr. Padilla's expert surgeon, whom Justice Kelly made no mention of, I think put it very well when he wrote, this is page 4946 of the record, he writes, the only piece of information that raised any level of concern for pancreatic cancer was the cytopathology report.
How can you say that given the patient's history? Both his parents had pancreatic cancer.
Well, we can all agree Mr. Padilla didn't have it. And we can all agree that Dr. LeBeau knew this on September 28th when he first met the patient.
Nobody's going to know it till the surgery happens. I think everybody agrees with that.
Then why did they wait for the biopsy?
I don't have to answer the questions, counsel.
It's a rhetorical one, don't worry.
Well, no rhetorical questions here. We have a clock ticking. I think you want to get right to the point.
Honor, Dr. LeBeau was clearly waiting for the results of the biopsy to integrate them into his decision to proceed to surgery. And he clearly was not going to proceed to surgery unless and until something in that pathology report led him to do that. The chronology shows he was waiting for it, and once he saw it, that's when he made the decision. That at least raises an issue of fact as to whether this pathology report was a proximate cause of that decision.
But didn't the report also say that not only did it find atypical cells, but that it should be correlated with other studies, such as diagnostic studies? So now you have the NYU report saying no malignancy. According to the experts, atypical doesn't mean malignancy. So now Dr. LeBeau is looking at the entire picture, right?
Yes.
So clinical correlation, his family history, and all of the other issues that he has, he says, you know what? Let's err on the side of caution and let's do this surgery.
Well, as our expert surgeon opined and as we've alleged, Dr. LeBeau was himself negligent in deciding to operate on the information he had at the time. He should have gotten further studies done. For example, the frozen biopsy was another procedure that could have been done. But just because Dr. LeBeau made a mistake in relying on this information doesn't mean that the information was not itself negligently prepared and that it did not itself constitute a departure.
Thank you,
Thank you.
counsel. You have some rebuttal.
Good afternoon, Your Honors. My name is Gina Bernardi DeFalco. I am here on behalf of Dr. Buick and Mount Sinai Hospital West.
So counsel said that,
I'm sorry.
counsel said that Dr. LeBeau integrated the entire report, and that would mean that he also considered the excess cells. What do you have to say to that, since the excess cells is the departure that they're talking about?
Well, I'll use Judge Kelly's words because I think they were right on point. Dr. LeBeau read the entire contents of the report, and he knew that she had reported the individual cells themselves were not atypical and did not show mitotic activity, which might be indicative of uncontrolled cell growth. He also read the qualifying language. What Judge Kelly concluded was that looking at the language in the report, looking at what the experts say, this could not possibly be the basis for Dr. LeBeau's decision. Plaintiff's own expert, expert surgeon from whom he read part of the affidavit says, this report did not definitively characterize the findings as malignant, but rather categorize them as atypicals, stating that if there is a distinct mass, the overall features are suspicious for acinar cell carcinoma. However, normal acinar tissue can yield numerous glandular acinar structures mimicking carcinoma. The totality of that is, yeah, it's probably normal. But I see this excess of cells. Plaintiff's expert goes on to say, if he had correlated the clinical data, which Dr. Buick recommended, he wouldn't have operated. According to plaintiff's expert, all the clinical data is pointing against cancer. So if he had integrated it, the integration of this report wouldn't have led there. And that's what Justice Kelly found, and Justice Kelly properly found. Justice Kelly relied on two things, the language of the report. The other thing he relied on was Dr. LeBeau's own testimony, that the only way to know for sure was to do surgery. The reason the only way to know for sure was to do surgery is because that's where you get—
Counsel, though, your opponent makes much of the chronology of events, and that after the report came out, the decision was made shortly thereafter to do the surgery. Does that give rise to an issue of triable fact?
I don't think so. My opponent also made an error when he recounted what happened at the tumor board meeting the day before. He said that they were going to wait for the pathology. They did write in their note that the pathology was pending, but the note also says plan of care, distal pancreatectomy. They made the recommendation at the meeting when the path was still pending. Now, full disclosure, Dr. LeBeau came back on his reply on his summary judgment motion and said they had read it, but they had considered everything. The fact that the pathology was the last thing to come in doesn't make it a logical conclusion. Plaintiff states in his brief, cites this case, Naaman versus Doshi Diagnostics out of the Second Department. He cites his burden. I have to put forth sufficient evidence that would lead a reasonable person to conclude that it was more probable than not that this report impacted the conclusion. Justice Kelly found he didn't do that. If you looked at the language of the report and you looked at Dr. LeBeau's testimony and the things that Your Honors asked the plaintiff about, that was not a logical conclusion. And if Dr. Buick is out of the case, Mount Sinai has to be out of the case. I understand they had an allegation that we were also vicariously liable for Dr. LeBeau, but they gave us a bill of particulars that only had the exact same allegations that were raised against Dr. Buick. They didn't incorporate by reference the bill of particulars as to Dr. LeBeau. They did not repeat the allegations as to Dr. LeBeau's alleged negligence. So I believe we were well within our rights not to address those allegations or in our initial moving papers. Justice Kelly went and searched the record and made a determination that Dr. LeBeau was employed by Mount Sinai West. But none of the proof leads in that direction. The proof does not lead to any direction that he had any employment relationship with Mount Sinai West. Yeah, he worked there. Yes, he was the chief of oncological surgery after the fact, but that doesn't make him an employee. That's not enough to make him an employee. So that part of the decision should be reversed, while the dismissal of Dr. Buick should be affirmed. If the bench has no other questions, thank you, Your Honor.
Your Honor, it's true, Justice Kelly did write in his decision that the report said that the results were not atypical. I was hoping counsel would point me to that language in the report, because when I look at, I see final diagnosis, pancreas mass, fine needle aspiration, including thin prep and cell block, atypical. If we're still confused at this point as to what Dr. Buick saw in this report, then there's clearly a departure. As to the issue of vicarious liability, counsel seems to think they weren't supposed to be on notice of it from the bill of particulars. I would direct this court to pages 7 and 8 of our appellant's brief, where we went through the allegations against Mount Sinai West and how they included Dr. LeBeau's conduct as well. These have been in the bill of particulars, and still, there's no evidence there's no prima facie evidence against vicarious liability. If you look at Dr. LeBeau's own testimony about what he was doing at the time, and that is pages 777 to 78 of the record. Question: in December 2016, what were your duties at Mount Sinai? What was your position there, if you could explain what your duties were? Answer: my position then was the Assistant Chief of Surgical Oncology for the Mount Sinai Health System. And I believe at that point I was a professor of surgery, academic rank. There's at least an issue of fact on this point.
Counsel, if I may, the bill of particulars as it related to the malpractice, it was just limited to the biopsy and the pathology. Am I correct about that?
I'm going to quote you chapter and verse, Your Honor.
And the reason why I pose that question is because I don't believe that Dr. LeBeau participated in that. Am I correct about that?
Dr. LeBeau did not.
That's a yes or a no. I don't think he participated in it. Am I right? Yes or no? Thank you.
Thank you. Okay, thank you. Thank you both. People versus Jonathan DeLeon.
Good afternoon, may it please the court. My name is Christina Rincon of Davis, Polk, and Wardwell, and in association with the Office of the Appellate Defender, I represent Mr. DeLeon. The trial court erred in overruling Mr. DeLeon's Batson challenge. The prosecution had 8 peremptory strikes before the Batson challenge was made, and 4 of them were against women of color. Defense counsel objected, specifically noting that the defense had stricken—
Counsel, wasn't Bridgeforth about colorism? So you can't just say women of color. You have to talk about women of a specific skin color.
That's right, Your Honor. And defense counsel here very specifically and explicitly several times said Hispanic and black women and tied it to the fact that his own client, who was Hispanic, had been mistakenly or that there was a question in the record about whether, in fact, he was black. And so the color of these women was relevant, potentially, to the identification of the defendant. And color could have been shared between the Hispanic and Black women.
Wasn't that also expanded at one point to Asian women?
No, Your Honor, that was something that the prosecution said, and defense counsel was very clear throughout that he was only challenging the strikes of Hispanic and Black women, and he explicitly noted that that was because his own client was identified as both Black and Hispanic.
The defense counsel also used a peremptory challenge to, against a woman of color?
He did, Your Honor, but that's irrelevant to whether there was a Batson issue here. Under the Court of Appeals rulings in Bollinger and in Jenkins, whether some women of color may get onto the jury or whether the defense strikes some women of color is irrelevant as to whether there was a discriminatory motive for the prosecution's strikes.
Counsel, I'd like to go back because the court had requested clarification as to whether counsel was referring to Hispanic women, Black women, and he said women in general, correct?
Correct, Your Honor. He was asked by the court, well, the court first said, you have to tell me what you're doing. Are you doing women? Are you doing Hispanics? Or are you doing Blacks? You can't have anything besides that. It's one of the three. And defense counsel eventually said it's Hispanic and Black women of color, and then had also mentioned separately that he thought that there were strikes against females in general. But our focus here is on the Black and Hispanic women of color.
But did counsel make that clear enough before the court?
He did, Your Honor. They spoke specifically about the jurors, Vargas, King, Truesdale, and Cuevas. He pointed them out. They were identified as jurors 2, 1, 14, and 16, and he used the terms Black female, Hispanic female, Black female, Hispanic female, counting down several times. The court also erred in holding that the defense had not established a pattern, and it was very clear, I think the defense counsel said at least 5 times on the record that they had struck 50% of the, 50% of the strikes were used against women of color, which is sufficient under this court's rulings and under the Courts of Appeals rulings. And finally, as I noted, Your Honor, the fact that some women of color may have made it onto the jury is irrelevant, and specifically the court erred by saying that the prosecution had allowed some women of color onto the jury and that the defense counsel had, in fact, struck them.
So to be clear, when the attorney said women of color, he was talking about color of skin, not ethnicity. That's what you're saying?
That's correct, Your Honor. Which under People v. Bridgeforth is perfectly sufficient. In People v. Bridgeforth, the challenges were to women of color, and it was Black and a South American woman. So Bridgeforth is really on all fours here and would instruct that this court needs to remand for the court to proceed to step 2 of the Batson inquiry. The court should also reduce Mr. De Leon's excessive sentence. He was sentenced to a total of 10 years, which was 2 years above this mandatory minimum, and the court should lower the sentence in the interest of justice. Mr. De Leon has a lengthy and well-documented history of mental illness from the time he was a small child. He began self-mutilating at a young age. He was treated with antipsychotics.
And wasn't all of that presented to the sentencing judge?
It was, Your Honor, but it's not relevant to whether on appeal you can consider whether in the interest of justice a lesser sentence is warranted given his cognitive disabilities.
What was the maximum that he faced?
25 years, Your Honor.
25 years, and he was sentenced to 10.
That's correct, Your Honor.
Just 2 years above the minimum.
That's a big difference to someone like Mr. De Leon. And so that's all we're asking.
He didn't get 20 years, he didn't get 15 years, he got 10.
That's correct, Your Honor, but just because the court didn't give him the maximum sentence doesn't mean that he is not entitled to a lower sentence given his particular circumstances and his particular disabilities.
What about the other circumstances that the court would take into consideration, such as the crime that he committed and his criminal record?
His criminal record was entirely nonviolent, and he did.
But he's a predicate felon, isn't he?
He was, and so that was obviously factored into bringing the minimum sentence up to 8 years. As I said, but his prior crimes were entirely nonviolent. And, this court has acknowledged in several cases that people with mental and intellectual disabilities may deserve a lesser sentence because their conduct is less blameworthy.
But as my client already indicated, these are things that were before the sentencing court.
They were, Your Honor, but this court has plenary authority to consider Mr. De Leon's circumstances and reduce the sentence in the interest of justice, and we urge the court to do so. This court's decision in People v. Watt is instructive. Mr. Watt was charged with attempted murder, which is very clearly a far worse crime than what we have here. And yet the court reduced Mr. Watt's sentence from 14 to 10 years because, like Mr. De Leon, he was diagnosed with severe ADHD from a young age and was determined to have low cognitive functioning. Watt also drank heavily, reportedly at the urging of his friends, and that also resembles Mr. De Leon's sentence. And so we urge the court to reduce Mr. De Leon's sentence to the minimum of 8 years. Thank you.
Thank you.
Good afternoon. Oh, excuse me. Good afternoon, Your Honors. Norman Stackhouse for the people. With respect to defendant's Batson claim, we're not disputing that jurors who share a similar skin color could be a cognizable group under Batson. We're disputing that the showing was made in this case. There's nothing in the record reflecting the skin colors of any of the jurors. Instead, defense counsel consistently referred to them as Black and Hispanic and even Asian. And he also never described his Batson challenge as relating to female panelists who were mixed and Black on the lighter side as he does in his brief. He specifically said defendant was Hispanic and that there was an issue as to whether he identified as Black. That's different from identifying his skin color and comparing it to any of the jurors. Defendant, even if women of color were construed to be a cognizable group, he did not make a prima facie showing of discrimination. His argument was purely numerical. He didn't show that any of the stricken jurors had a pro-prosecution background, that the prosecutor had made any statements during voir dire, during questioning that would indicate discriminatory intent. And it is relevant at the first stage whether members of the class have been seated. At the point in time when the Batson challenge arose, out of 10 jurors, 4 were women of color. No further questions, I'll go to the sentence. Something above the minimum was warranted in this case. As Your Honor pointed out, the maximum was 25 years, the minimum was 8. The judge considered everything that the counsel has put in her brief and appeal, and he came to the conclusion that even if defendant had mental limitations, that the things he was describing, such as ADHD, don't...
Counsel, can I interrupt you? Defendant said that there were no nonviolent priors. Wasn't there a youthful offender?
There was a youthful offender.
It was a robbery that he brandished something that looked like a gun anyway.
And I was going to get to that, Your Honor. There was a 2006 conviction. He was adjudicated as a youthful offender for a robbery in the second degree, displays what appears to be a firearm, which is actually a violent felony. So it's not true that he doesn't have a violent history. And this case, as we pointed out in our brief, is not like Watt. The defendant in that case had really severe mental limitations, which made him overly susceptible to the influence of his peers, who kind of coerced him into participating in the crime. Whereas here, the defendant was the person who was egging on and coercing, from what the record reflects, the younger defendant into participating in this crime. And he also has a criminal history, whereas the defendant in Watt didn't have anything. If there are no questions, I'll ask the court to affirm the conviction.
Thank you.
Your Honors, the defense counsel was very clear about the fact that he was challenging the women of color.
But I just want to make sure about something here, because, when I see it, he says that the people knocked off the only member of the panel who was a Hispanic female. Then in the second round, he says the people knocked off a Hispanic female and 2 Black women. He also mentioned, again, persons of color, in particular Hispanic and Black. So he's not really, and then he says again, with regard to that the defendant is Hispanic and that there was an issue in this case as to whether he was properly defined as being black. I mean, he's never really, there's nothing here where I hear, I'm saying Hispanic and black, but when I say Hispanic, I'm referring to, you know, dark-skinned people or whatever skin people, and when I'm saying black, I'm really referring to the color of their skin. There's nothing here that says that. He simply says persons of color, but it seems as if it's interchangeable with ethnicity here. There's nothing that I see, if you could point me to, not simply the use of the words, because he uses both so many times, it's hard to see that he's really talking about complexion.
Sure. So if you look on page 319 of the voir dire, Your Honor, he specifically says that the overwhelming percentages of them have been persons of color. And he also says that at the bottom of 318 and 319, there's been a significant number of women of color. Yes,
but then he goes on to speak about every time he's speaking about Hispanic or black. And so but there's nothing there where he identifies what he's talking about when he says women of color.
You're correct that he doesn't say, Your Honor, specifically, oh, women of a, you know, specific skin tone, like dark-skinned or light-skinned. But I think it's quite obvious by implication that what he's talking about is, I mean, when the prosecution said, oh, and there's an Asian woman too, and she's a woman of color, defense counsel could have said, great, let's include her as well. Like, that helps my numbers. But he didn't. He was focused on Hispanic and black, and he also discussed how the court thought that some other woman was Hispanic, and he said, well, to me, she was white. And so he was obviously going by what they presented visually and tied it explicitly to the fact that his client had a ethnicity or race that was potentially illegible to the people involved in the case.
Thank you.
Thank you.
Thank you both. Yes, oh, thank you for reminding me. Yes, you're from Davis Polk. Appreciate your pro bono service. Thank you very much. Scottsdale Insurance versus Mount Holly. When we ask our questions. Yes.
Thank you very much.
Good afternoon, Your Honors. I am Eric Subin from Traub, Lieberman, Strauss, and Shrewsbury, and I represent the appellant, Scottsdale Insurance Company, in this case. In this case, Scottsdale is requesting that the court overturn Justice Engeron's order granting summary judgment to the appellees and denying Scottsdale's cross motion for summary judgment. In his ruling, Justice Engeron, in our view, erroneously rejected Scottsdale's well-established right to equitable contribution from co-insurers of the same
Counsel,
insured.
when Scottsdale settled the underlying lawsuit, you didn't notify underwriters, right? You just went ahead and settled it.
I believe that's correct.
Now, is that inconsistent with your position concerning the horizontal exhaustion doctrine? You'd think that they'd have to be involved if they were next in line in insurance for insurance purposes.
I understand that there is that line of reasoning in some of the cases that were cited by the appellees in this case. However, I would say in this case, the record was quite clear, or at least the facts were quite clear at the time, that underwriters and Mount Holly were very well aware of the case and of the exposure and of what was happening in the case. They were not invited to the settlement conference. I have to acknowledge that based on the record that I've seen. But I believe that the fact that they were aware of the claim and the potential magnitude of the claim, in my view, should suffice to hold them responsible for equitable contribution on the facts of this case. What I'd like to start by stating is that I believe it's Mount Holly in their brief suggests that Scottsdale wants to walk away from the settlement that it negotiated on behalf of 175 Broadway. And I'd like to point out that many of the cases that are relied on by the appellees here are based on the premise that the insurer seeking contribution is trying to turn the clock back to the status quo ante, in other words, to where they pay nothing. That is not the case here. Even if Scottsdale prevails on this appeal, Scottsdale will have paid $1.4 million on behalf of underwriters and Mount Hawley's named insured. And as such, what we're seeking here is equity. In other words, it's not that we're trying to say Scottsdale should have never paid anything. What we're saying is that the loss or the payment should be spread under equitable principles and under the principles that this court articulated in the Bovis and...
Not contractual principles?
I'm sorry?
So you're arguing from equitable principles, not contractual principles?
Well, that's a great question. Those two facets exist in tension, I would say here.
We're bound by the contract.
Under Bovis, the contractual principle is the contract that each insurer has with its own insured, and specifically the other insurance provisions of each of those policies. The equitable principle is the spreading of the loss among insurers. I mean, it's equitable contribution. That's the name of the doctrine. And it's that all of these insurance policies were exposed for this risk. All of these insurance policies were inarguably on this risk. And so the question is, how should the risk be shared among these policies?
Well, there's another contract that you didn't mention, which is the contract between the parties, which has got a broad indemnification provision, and I don't really see the way around that.
Your Honor, I agree that there was a broad indemnity provision in the underlying construction agreement, but the court in Bovis specifically rejected that argument that the appellees have raised, that the existence of an underlying indemnity agreement trumps the other insurance provisions of the policies. That citation is, I believe, 53 AD 3rd at page 145.
But you're talking about Bovis, you're talking about, governing the priority of the service, but here there's this pass-through. So that the whole idea about the priority of service really doesn't apply here.
That's where we disagree with Justice Engeron and with the appellees, Your Honor. It's our argument that the ICNY case, which is relied on heavily by Justice Engeron and also by the appellees, was based on a record, and so are the other cases cited by appellees, was based on a court record where liability had been determined. In other words, it had already been determined that the project owner, in this case 175 Broadway, was liable. That had been determined as a matter of law. That never happened in this case. And so it's our argument that it cannot be said that the indemnity was triggered at the time that the case was settled, and as such, it has to be, the law should be distributed under equitable principles based on priority of coverage.
Thank you.
Good afternoon, may it please the court. Michael Savitt from Clark and Fox on behalf of respondent certain underwriters at Lloyd's. I think it's telling by the absence in my adversary's colloquy, no mention of the governing authority in this case, which is this court specifically addressed this very issue in IICNA versus St. Paul, in Arch versus Nationwide. Those two cases really dictate, in my opinion and in the opinion of my client, the outcome of this case. IICNA in particular is on all fours. Justice Renwick, you were on the panel in that case, and all of the, as my colleague from Mount Holly described in his brief, if you match up all the parties in that case and the carriers in that case to this case, you have an identical match. Both IICNA and Arch, which incidentally in the trial court for Arch, Justice Ostrager wrote that opinion, which this court upheld. Justice Ostrager literally co-wrote the book on insurance law. So I don't think there's really any ambiguity here. When you have a scenario, which we have here, which is before the court, you want to call it equitable contribution, you want to call it subrogation, you want to call it, whatever you want to call it. At the end of the proverbial day here, Scottsdale and Mount Holly, whether it's through the insurance or through contractual indemnity, will be made whole. If Your Honor, if you look at the page 22 of the record, which is a flow chart that I submitted as part of my briefing to the trial court, that sums up the essence of this case. From start to finish, no matter how you get there, you still end up from point A to point B, which is that Scottsdale and Mount Holly should not have any indemnity obligation. Are there any questions?
Thank you. I think it's clear.
Thank you.
Good afternoon. May it please the court, Timothy Delahunt for Respondent Mount Holly Insurance Company. I thank my colleague for arguing first. I have nothing further of my own to add. And if there are no questions, I thank you.
Thank you.
I do have one point in response to what Mr. Savitt argued, Your Honors, and that is that there's no issue of subrogation before the court, and this is also a concept that comes up frequently in the appellee's briefs and also in the cases that were cited. We're not trying to subrogate against our own insured. Scottsdale's not trying to subrogate against its own insured. It was never determined in the underlying case that anybody was at fault vis-a-vis this plaintiff. And so, again, it's really a question of the one insurer's right of contribution against a co-insurer of the same risk. It's not Scottsdale's intention to go after 175 Broadway to recover back the money, and it's not, as I said at the outset, Scottsdale's intention to get back the $1.4 million it will have spent in any event to settle the claim against 175 Broadway. It's not a subrogation issue, it's strictly equitable contribution. Thank you.
Thank you all. People versus Malik Jones. May begin.
Good afternoon, Your Honors. My name is Tomoe Murakami-se, and I represent Malik Jones. Malik was sentenced to many multiples of the minimum sentence, despite his youth, the fact that he's a first-time felony offender, his active involvement in the 4.5-year conspiracy alleged in the indictment was limited to a period of about 1 month, which itself came right after he himself was victimized. He was shot. And after that period, he left New York and he left the conspiracy. By the time of his arrest, more than a year later, he was in Georgia, starting a new life and staying offense-free. He was working on his GED. In prison, he's been singularly focused on getting back to his family, to Georgia, his mother, an ICU nurse, his partner, who has stood by him all this time, and their daughter, who is anxiously waiting her father's return. The modest reduction this Mr. Malik seeks is appropriate in this case. I'd like to expand a little bit more on the period of heightened activity that is the focus of his involvement here. There's 2 incidents involved. The overt acts associated with Mr. Malik in this, 36-person indictment. The first of those incidents is a January incident, which was an attempted gang assault, an assault which involved multiple people. He was one of them, and he didn't plead guilty to that. But the second incident is the incident that involves his two charges. This February 9th incident, he was not present at the time of the shooting.
But counsel, you have to concede he played a large role in organizing the attack.
Your Honors, what happened, what the indictment alleges, and that's all we have here, because he pled right away.
I should have amended my question that way, but the indictment does set forth a great deal of involvement in planning for the attack.
As to this incident, what the indictment says exactly is the co-defendant, Maurice Culp, posted on a Facebook message to co-defendant Paul Washington. These are both two adults with substantially more of a record than Mr. Jones, asking for a gun. At that same time, Malik caused or permitted, quote, caused or permitted to be posted on Facebook a message to Washington stating that Washington should bring a firearm the following day. And Malik was part of a group of about 10 individuals who on that same day, as the posting, walked over to the neighborhood of the Manhattanville houses. Some in the group, but not Malik, then entered the Manhattan houses with a gun, roaming until they ran into a rival gang member and shooting that person. Though respondent claims that Malik remained at the Manhattan houses during the shooting, Malik was not among those who went into the Manhattan houses. And he was also not present at the time of the, he was also not present when the people involved in the shooting met up with the other co-conspirators after the shooting and ran back to the Grant houses. I mentioned two names, Paul Washington and Maurice Culp, two adults, and they were not charged with the attempted assault in this case. And so as a result, their sentences are 56 months to 14 years on just the conspiracy 2 charge. That's all they pled to, and 6 to 12 years on the conspiracy 2 charge. And so as a result, they, on the long end, yes, it's more than Malik's sentence of 5 to 10. But in essence, what Malik got was a 10-year determinate sentence because he was also charged with the attempted assault in this same February incident. Again, Malik is not the person he was. He'll be returning to Georgia where he was at the time of the arrest.
And he has no criminal activity in Georgia, no convictions, there's nothing in Georgia?
In Georgia, prior, so after he left the conspiracy and went back to Georgia, he was focused on his family, his little girl, and his GED. He did have two incidents, 2 convictions in Georgia prior to his moving to New York, which set him into the center of gang activity. Prior to moving to New York, he had a
But upon his return, he didn't. After he was shot and he went back, then
he went back. There's nothing after that. No.
Nothing after that.
But
And so, with regard to the activity that you mentioned, he didn't go into the houses involved at that point, but he provided the weapon.
He did not.
People who went into
No,
the
what he did is he posted he was one of 2 who posted the indictment says, Malik caused or permitted to be posted on Facebook a message to Paul Washington stating that Washington should bring a firearm the following day.
Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the Court. Jennifer Mitchell for the people.
So, counsel, just let me ask you, does he have a felony record? Doesn't seem like he did before this.
He did not have any felonies before this that was known to the sentencing judge before, so it was already taken into account at sentencing. We're asking...
I see that he has the conspiracy charge. I mean, he did plead guilty right away. He has a 10-year determinate sentence.
Yes.
Which prevents any sort of reduction while he's in prison, really. I mean, it's not like he could hope to get, he's got to do the 10 years.
Yes, Your Honor. He was sentenced to a determinate term of 10 years for the attempted first-degree assault charge, followed by 5 years of post-release supervision. So if this court does have the power to reduce, in the interest of justice, his post-release supervision term to the minimum of 2.5 years. However, under the Less is More Act, there's really no reason for this court to do so, because with good behavior, he will receive that same relief he seeks, because for every 30 days of good behavior, he'll receive 30 days off his term of post-release supervision, which will equal out to about 2.5 years. We're asking that the court not disturb this lenient sentence in light of the severity of defendant's crimes. For years, defendant has played a prominent role in a conspiracy to rule over an area of Manhattan through the use of fear, violence, and intimidation. Defendant was directly implicated in a violent gang assault where he continuously stomped on the victim even after the man was already forced to the ground. He also played a prominent role in the shooting of a rival gang member by directing other members of his gang to get the gun that was used in that shooting and then escorting those members over to that rival gang area in order to carry out said shooting. Defendant was facing 11 different felony counts, but only had to plead to 2 counts in exchange for this lenient sentence that he received. On the top count of first-degree conspiracy alone, defendant was facing a minimum indeterminate term of 15 to 25 years, but was able to plead to the lesser crime of second-degree conspiracy in exchange for an indeterminate sentence of 3 1/3 to 10 years. Defendant's purported mitigating factors that he cites were already fully considered by the sentencing judge and do not warrant a reduction in this case. Accordingly, this court should not disturb defendant's sentence on appeal, and if there are no further questions, then the people ask that you affirm.
Thank you.
Thank you.
Your Honor, Malik is not asking to be absolved of responsibility. He fully accepts responsibility. He pleaded guilty right away. But his long-term exposure to violence in his community, the direct violence against him that he experienced before his crimes of conviction, his youth, his ability to rehabilitate. I'm not sure if I mentioned that he did get his GED in prison right away. So he did finish what he started in Georgia. The fact that he's a first-time offender, and the fact that he is a mature person now, focused on going back to his family in Georgia, where he was living at the time when he was arrested, warrants to support the modest reduction of his lengthy sentence. And as to the PRS, this court should reduce to the minimum, because even with the Less is More Act, and even with perfect compliance, his PRS of 5 years would still result in a range that is longer than what Cy Vance and who prosecuted Malik and others, law enforcement authorities and supervision and law enforcement authorities have said is, effective. They've said it's not effective after 12 to 18 months, and reducing to the minimum of 2.5 would accomplish that 12 to 18 month range. And again, this is a sentence that is many multiples of the minimum. Perhaps something a little bit more is warranted. It is a serious act. He fully acknowledges that, but it's still what the sentence he got was excessive. Thank you.
Thank you. Thank you both. Condor Capital versus Cal's Investors.
Good afternoon, may it please the court. My name is Daniel Johnston. I'm of counsel to the Bell Law Group. I represent plaintiff appellant Condor Capital in this matter. This appeal is taken from a February 8th order from the lower court, which erred in finding that the instant claims were barred by reason of res judicata, premised upon an earlier order of Justice Scarpula.
Yeah, counsel, there's a really distinct feeling in this case that we haven't gotten past the finish line for some reason. Now, why in Condor 2 did you not raise the two provisions you're seeking to raise now, sections 8.08 and the other one, section 10?
They were brought in the earlier action in opposition to defendant respondent's motion to dismiss, which I will admit is...
No, but why not plead them in the first place?
They should have been pled specifically. They were inartfully pled erroneously, as there was a negligence claim generally under common law, which by admission was not the proper way to go about it. When plaintiff appellant did respond and raise the issue of these two provisions, which would provide a direct breach of contract claim for negligent servicing, Justice Scarpula at oral argument demonstrated an intent that they were going to be dismissed without prejudice with the right to replead, specifically stating that maybe what I should do is, just because I think that's right, I don't think you can, in response to a motion to dismiss, raise this whole new thing and then not give me time and not give move-in time to flush it out. That's really, I think, probably the thing to do in that circumstance is to dismiss without prejudice to replead. And sure enough, in the order states, these sections of the PPA were raised for the first time in Condor Capital's opposition to the motion to dismiss. Because Condor Capital improperly argued in support of a breach of contract claim based on the sections of the PPA that are not pled in the FAC, I do not address the argument. Based on that, I do not address the argument. How can something be deemed ruled on the merits if they weren't addressed? And secondly, apologize. Yes, I mean, that cannot be considered a final determination. If it's been said, I'm not going to address these arguments. The most on-point case in this was quoted at length in our brief, which was Komalov versus Siegel, which is 96 AD 3D 513. In this case, similar set of facts in terms of the procedural ongoings, and it stated that dismissal of this action on grounds of res judicata and collateral estoppel with the informal directive that plaintiffs seek relief to amend their pleadings by motion to renew before the court that presided over a prior action commenced by plaintiffs was error. The dismissal of the prior action should have been without prejudice, since the claims in that action were dismissed for pleading deficiencies and not on the merits. And going back to that quote in the subject order from Justice Scarpula, she says this is not pled, and therefore I'm not considering. So we have a pleading deficiency, and we have a determination that's not on the merits. While I understand that there's a lengthy history of litigation here, this is a potentially meritorious claim, and plaintiff appellant should be allowed his day in court. At the minimum, I would ask that the findings of the lower court that sanctions were warranted, that this is a frivolous case, those just are not supported by the facts and the law that apply to this case. We do have a bright line rule that, despite any argument against it, stands, which is where a dismissal does not involve a determination of the merits. The doctrine of res judicata does not apply. Are there any questions I can answer?
You have some rebuttal time, so
thank you.
Can address anything there.
May it please the court, Your Honors. Dan Gimmel from Kane Kessler for the defendants' respondents.
Counsel, given the colloquy that happened in the court, where counsel has just reiterated it here, where the court says, you know, I probably should give you the opportunity to replete, and she goes through, you know, the fact that this is new, and counsel, whoever it was, also says, well, you know, with regard to the argument, he says, well, he is now. In other words, the court says, has this ever been raised? He said, well, he is now, after seeing the motion to dismiss. So even he makes clear, or she makes clear, that this was not something that was pled.
Yes, Your Honor, that was actually me.
Okay, so you. So then there's no question that you were saying at that time, hey, this is not here.
Sure.
Yeah.
So, Your Honor, let me just back up for a second. The issue was that plaintiff made a deliberate decision to plead 3 counts against my clients in the prior action. Count 1 was breach of contract. Count 2 was for breach of implied covenant of good faith and fair dealing, and count 3 was for alleged negligent servicing of the loans. In each of those counts, the crux of the allegations and the gravamen of the alleged wrong was that there was a third-party litigation that was settled, and that the costs of the settlement and the litigation were deducted pursuant to a mathematical formula under the agreement to reduce a potential earn-out payment. And in each of those allegations in the prior action, those were the exact same allegations. Once we moved to dismiss the negligence and the good faith and fair dealing claims in our opposition papers, they realized those were duplicative. And they said, wait a minute, we can cite sections of the contract where we're going to reform
I think the judge, Sally Ann Scarpula, made it kind of clear what they were saying, and you agreed.
I agreed. However, the crux of the allegations, the claim was, all of it was based on the allegation that the deduction of the cost of settlement was improper and damaged the plaintiff. Justice Scarpula ruled, as a matter of law, that that deduction and the reduction in the earn-out payment was not a breach of the contract. So it's irrelevant how you get to that breach, but that alleged breach, the operative breached, is pleaded verbatim in both cases. And if your honors would look at paragraphs 75 and 77 of the present complaint, which is on pages 34 and 35 of the record, you will see that those allegations are verbatim to the allegations of the first amended complaint in the prior action that Justice Scarpula said could not state a claim. And those were 55, 57, and the prior action record pages are 367 to 368. And I will read those provisions for your honor. They say as follows. Paragraph 75 states, currently, CALS and the securitization trusts have breached the PPA by subtracting the funds paid to defend and settle the class actions from the equation used to calculate the earn-out payments due to Condor under the PPA. Paragraph 76 says, CALS and securitization trusts have breached the PPA by forgiving $14 million or more of loan deficiencies, rendering them uncollectible. Paragraph 77 says, as a result of the foregoing, Condor has been damaged in an amount to be determined at trial, but in any event, no less than $5 million, verbatim in the prior action. Those allegations, Justice Scarpula stated, could not state a breach of contract. They are now alleging the same breach of contract claim, except they've added 3 paragraphs where they've converted the prior servicing claim, and they inserted it into paragraphs 71, 72, and you will see that when you compare those...
Didn't they seek different levels of damages in each of the 3 actions, each of the 3 complaints?
No, identical. The
I thought
entire...
it was 1.87 in the first one, 10 mil in the second one, 5 mil in the third one, but I'm incorrect about that. I can check. I mean, I thought that was the case.
Well, as you, this is the third claim, and each of the cases seeks additional payments consideration for the sale of assets. Mm-hmm. And the first complaint in the second action sought 10-something million. The first amended complaint, which is the one that issued here, was 5 million. And that is, again, those paragraphs are lifted and they're copied and pasted into the new claim, which under the New York law of the Court of Appeals and this court's is clearly barred by res judicata.
Thank you.
To address two of the points made by my colleague. One is there appears to be a conflation here of breach versus an element of breach of contract. What Justice Scarpullo considered in what we'll call as the second action here, where the ruling was made, was that the deductions itself, as it was pled, the act of deductions and the way that the deductions were calculated, that could not sound as the breach of contract. The subsequent action is a different concept entirely. It's the servicing negligence, which there are contract provisions which ultimately result in, by breaching, they cause damages. How do we measure those damages? Well, one potential way is to look at how my client was damaged in the windfall provision. So these are two separate things, alleging you calculated it wrong, this is what you did wrong, versus you serviced your loans incorrectly, resulting in amounts that should not have been considered in the calculation. These are two separate concepts. And the second one of which, again, Justice Scarpullo specifically said, she does not believe that they were sufficiently pled. She's not going to address them in the motion to dismiss. We have an alive claim here. And second, just to make clear, while yes, this is the third action, they are distinct in their own right. The first action was related to how certain charges were being calculated related to servicing. The second one had to do with a class action that was settled in Pennsylvania related to the servicing negligence. And then Justice Scarpullo dismissed that case, brings us to the current instant matter. The first action really has no bearing on the second or third. They're distinct sets of facts. And as discussed, we have a bright line rule here no matter what's thrown at it. If there's no determination of the merits, there is no res judicata. This case should be allowed to go forward. Thank you.
Thank you. Thank you both. Core Group versus MIP One Wall.
May it please the court, excuse me, David Tannenbaum from Stern, Tannenbaum and Bell for Appellant Core Marketing Group, LLC. This is an appeal from an order granting the then defendants, this time respondents, motion for summary judgment that was made pre-discovery to dismiss the entirety of plaintiff's complaint, which was granted, including its cause of action for breach of contract under the parties' May 18th, 2016 co-exclusive sales and marketing agreement. It's our position that the court below committed reversible error by granting the summary judgment motion for a couple of reasons.
What is the provision of the contract on which you rely for your client's claim?
Your Honor, there is a responsibility.
No, I didn't ask you about a responsibility.
Yes, all right, it's under
What is the provision of the contract that you rely on for your claim? Because it seems to me, since it's a relatively, if as I would think, it's an unambiguous contract, then you would need to base it in the plain language of the contract. What are you relying on?
I understand. Paragraph 2, Romanet 4, required the owner of the building to open up a sales center.
Where does it say they're required?
Commencing on or about May 1st, 2017, activity at the project sales center will commence. It can't commence if they don't open a sales center, Your Honor. They were required to open a sales center. I don't think that issue is in dispute here. Their point is that if the sales center, whether or not you open the sales center, doesn't matter if they terminate you within 3 years, unless you didn't have the opportunity to do the selling within 3 years, then you would get a termination fee of $750,000.
I don't see where it says that they're required to open a sales center.
Well, Your Honor, if commencing sales from a sales center is going to begin on or about May 1st, 2017, that sales center has to be opened up. That's the responsibility.
No, that's when it ends.
No, that's when it starts.
Okay, but the termination and payment were not tied to opening the sales center.
Well, it is, yeah, well, their argument is it is if you look at the third year. The intent of the parties here, Your Honor, was that we were going to have 12 months.
But we only get to intent if there's an ambiguity in the contract. I still don't see the ambiguity. Paragraph
Okay.
2.
Very simply, Your
It seems
Honor.
to me it commences on the date, and it continues until the earlier of two things, one of which involves the sales center. But if they don't open a sales center, then it terminates in the alternative date, the closing of the remaining unit. So
Well, Your Honor, nobody is going to anticipate that 600 units in a very fancy building with
we don't
expensive
get to
units
what-
are going to be
excuse me,
sold.
counsel, we don't get to what no one would anticipate unless there's an ambiguity in the contract.
That is
Where-
correct, Your
excuse me,
Honor.
where is the ambiguity in the
The
contract?
ambiguity in the contract is what damages is my client entitled to recover if they terminate after 4 years and haven't opened the sales center.
But
This
where
was-
do you get to 4 years? That's my problem. It seems to me that they only get a termination fee in the first 3 years.
that they're limited to a certain amount. Excuse me, I'm a little bit tall, I apologize. You can hear me?
Yes.
Yes, during the first 3 years, if there's a termination during the first 3 years, these are what the damages are. Paragraph 7 doesn't say what the damages are if you go past the third year, go to a fourth or fifth year. Stay with me, please. I understand what Your Honor is thinking. And then you terminate me. They have an obligation to open up a sales center. They never did it. That's why
I'm still, could you show me again where they, it says that they must enter
Can you
a
look,
sales
please? It's on page 82 of the record. Is the record in front of you?
center? It is.
All right, you're looking at paragraph 2.4?
I am.
Okay. That says commencing on or about May 1st, 2017, activity at the project sales center. So that does anticipate that there's going to be a sales center. I don't see how that can't be seen. So there's going to be a sales center. They never opened up the sales center. And so we never had an opportunity to do any sales from the sales center, which was really the prime place where we were going to make our money for all the work that we were doing. We were doing all this pre-sales marketing work, and our fee was going to be from making sales from the sales center, which is where you can sell these units. You can't sell them by the internet. You can't sell them by people cold calling in. You sell them by doing it at the sales center. They never opened up the sales center. That's why if you take a look at what they've pointed to, which is section 7, see, you'll see that in the third year, it said if we didn't open the sales center, it says you get nothing if we terminate you in the third year, but if we didn't open up the sales center by the third year, then we give you $750,000. Because the parties always anticipated that the seller was going to do what it was contractually obligated to do.
Okay, I'm
and
going
that
to
was
stop you
open the
here,
sales center.
and you can finish up on rebuttal, okay?
That's fine, thank you.
Okay.
Good afternoon. Lori Ankernoff from Rosenberg and Estes, representing MIP One Wall Street.
Could you address the issue that counsel was just talking about whether your client had an obligation to open a sales center?
What counsel is doing is conflating and asking this court to change around the existing terms of a contract that was negotiated by sophisticated parties, whether there's a reference in this agreement to a sales center. There's no obligation. This, as the court pointed out, this agreement can be fully performed and can end by its own terms with them earning payment without a sales center. That's how it's written, by a sophisticated party. What?
They did earn payments, correct?
Exactly. They negotiated, if you look, it's record pages 84 and 85, the compensation provision, it's not tied to a sales center. There's a marketing fee. They got $450,000, a monthly marketing fee they negotiated. And, Your Honors, this agreement, it commenced upon execution. The right to earn money did not in any way tie into when a sales center was going to open. They started earning. They submitted evidence to show that they sold 10% of the units. And they earned, when these close, they will have earned at least $1.5 million. They also negotiated and received advances on commissions. And I'd also like to point out in 2018, December 2018, the parties entered into an amendment of this agreement. And at the time they entered into amendment of the agreement, it was, again, 2.5 years into the term. There's no mention of a sales center or lack of a sales center. The parties agreed actually to an increased commission, and in terms of, and then they ratified all the terms of the existing agreement. So there's nothing about that. And if you look at the arguments that CORE is making, what they're asking you to do is, so take paragraph 2, which defines the term, which commences on the day they sign it, and expires either on the earlier of 3 years or when they sell out, and they want you to cut out Y, excise that term, right? Because they're, and then they say, okay, now just read that portion of 2, then go over to paragraph 7, and when you read paragraph 7, 7C Romanet 3, which governs the 3rd year of the term, and they do not dispute that the 3rd year of the term, that's a quoted term, 3rd year of the term that's referenced in that section, it expired in May of 2019. And they do not dispute that they were terminated 2 years later, almost 2 years later. It was 4 years, 10 months into the term. So they want you to take that section, which says if they were terminated in the 3rd year of the term and a sales center hadn't been open, cross out the portion that says 3rd year of the term and say, in any year of the term, if a sales center hadn't been open and they didn't have the opportunity to operate out of a sales center for 12 months, then they'd be entitled to a fee. The document doesn't say that.
So a sales center, the lack of a sales center does not hinder their ability to sell any of the apartments?
They sold. They sold it, and there's actually another provision in the agreement where they can work with other brokers and have them involved, and then there's a splitting of a fee, and there's a provision which governs that. So it contemplated other matters in which this would sell, and it did sell. So, thank you. Unless there's any other questions.
Thank you.
Counsel, if I may.
Yeah, sure.
Where in the agreement does it indicate that defendant had the obligation to give you the opportunity to sell from a sales center?
Okay. I agree with you. I would be much happier if there was a sentence that explicitly came out and said that. Of course, I would
not,
be.
right?
It is, but you can. You can look at it in Section 7. If you look at Section 7C, we get $750,000 if they terminate us before we have the opportunity to sell 12 months at the sales center. There's no evidence in the record about these amazing sales.
Well, it's actually what opposing counsel indicated, that that related to the 3rd year of the term and the passage of 12 months from the opening of a sales
No, that's not from
center.
the, yes, correct. It gives us 12 months. It
But-
says, Your Honor.
Okay, but I want to stick with this sales center, because you're stuck on it.
Yes,
So
I am. It's my
where
case.
in the agreement does it say that you have to sell from a sales center? You know, I don't see it. I don't see anything that says what would happen if the sales center didn't open. There's nothing about defendant being required to give you the opportunity to sell from a sales center.
Well, Your Honor, it does say that in the 3rd year, if the sales center isn't open and we don't have the opportunity to sell from the sales center in the 3rd year, then we get $750,000. Think about that. How silly an agreement would this be if they can fire us in the 3rd year? They have to give us $750,000. But if the sales center isn't open up in the 4th year, the 5th year, the 6th year, the 7th year, we don't get $750,000 while we're continuing to put in our efforts to do things. It's implied in the agreement. I agree with you. I would be much happier, my firm didn't have anything to do with drafting this agreement, if it had come out and there's a paragraph that says that. But it is throughout this agreement. It is understood. That's why it's a 3-year agreement. They were supposed to open up the sales center by the 2nd year. They never did. And by firing us one day after, if they fired us one day after the 3rd year, they don't have to give us a termination fee? That doesn't make any sense when we're continuing to work.
They
It is
fired
not
you
the
almost
intent of the
2
parties.
years after. 2 years after is when they, 2 years after is when they basically terminated the agreement.
They did it after 4 years, almost 5 years.
Exactly, almost
Right.
5 years.
And so that's another 2 years of effort that we put in that we're not getting paid
73C
for.
says that if they do it within the 3rd year, then you get a fee.
Right.
Then you get a termination fee.
But why, but think about that logically. Why, then if we can continue to work and they don't open it, and we're doing more work, we still don't get fees because somehow it's past the 3rd year. It's obvious that they had an obligation to open the sales center. They didn't do that, and because they didn't open the sales center, we couldn't make the fees. The fees are at the sales center. That's where the majority, that's where you make the money. And that's what this was designed to do. We never had the chance to do that. At the very least, we should be given discovery so that we can see that our understanding of the agreement is the same as theirs. It's not as crystal clear as I believe the court thought when you were asking me those questions. I understand that.
Thank you,
But
sir.
there is an ambiguity here.
Thank you.
I appreciate you giving me extra time. Thank you.
Thank you both. 2010 Powell versus New York State Division of Housing.
May it please the court, Nativ Winiarski for the appellant from the law firm of Cook and Marina, Winiarski and Bittens. So the courts of this state, and specifically this court as well, have laid forth their firm imprimatur on the well-settled, almost proverbially rule that a decision by an agency is necessarily arbitrary and capricious when you fail to follow your own precedents. And that's exactly what happened here. The precedents of the DHCR, when a tenant files a rent reduction complaint and then vacates, pursuant to the DHR decisions in Zushin, in Wahid, in Oriolan, in HJW Realty, and a plethora of decisions we cite, in every single instance in which a tenant files such a complaint and then vacates, that complaint is then dismissed for lack of jurisdiction for 2 very simple reasons. Number 1, pursuant to the code, the tenant has to have an obligation to pay rent. A departing tenant has no obligation.
Counsel, at the beginning of this complaint, the tenant was in occupancy, correct?
It was an occupancy.
Isn't that an important distinction of the cases you decided?
No, if you look at Wahid and if you look at Zushin, the tenant's actually vacated at the par level. And that's part of the supplemental decisions that we set forth in our brief. If you look at Zushin, they left at the par level, and the same thing in Wahid. So in every single instance, whether it's at the rent administrator level or at the par level, if the tenant...
In Wahid, the tenant had moved out before filing.
Excuse me?
In Wahid, the tenant had moved out before filing.
Before
Before filing the complaint with DHCR.
No. If you look at Wahid, the agency did a reinspection, and then there was a new tenant. It did a reinspection at the par level. And then they did a reinspection. They found out the tenant was no longer there. And in view of the fact that the tenant failed to dispute that he had vacated the subject premises, the tenant's par is hereby rendered moot, as the tenant has failed to establish his legal standing to continue as a party in this proceeding. And the reason is again, for 2 reasons. 1, the tenant has no further obligation to pay rent. And number 2, the remedy of a rent reduction, of a reduction in services complaint is a reduction in rent, which has no application to a tenant who's departed. To this, the DHCR, in its par decision, they don't address that, but rather what they say is, it's irrelevant whether the complaining tenant no longer lives in the subject building, as any rent decreases in the instant matter are applicable to the apartment of any and all complaining rent-stabilized tenants.
Counsel, did you need to raise these cases before the trial court?
No, and the reason before the Supreme Court?
Yeah.
Okay, the answer Well, we did raise these arguments before Supreme Court. What the Supreme Court said is you defaulted at the rent administrator level, and therefore you couldn't raise the de minimis arguments. The problem with that argument is if you look at the PAR decision, the PAR decision addresses the merits of the claim. Specifically, at the PAR level, we raised both the fact that the tenant vacated and the fact that these services were de minimis. At the PAR level, they address these cases on the merits, and this court has held in Eastern Pork Products versus DHCR that the Supreme Court is limited to the determinations made at the PAR level, and irrespective of the fact that if you wanted to raise the argument that a landlord didn't answer the initial rent administrator's argument, that would have had to been raised at the PAR level, but the PAR addressed it on the merits, and so when you're reviewing the PAR determination, you are limited to you're limited to the arguments and the determinations addressed by DHCR. So the problem with DHCR's PAR level argument is fivefold. Number one, when they say that it was applicable to all complaining rent-stabilized tenants, well, the fact is there were no other complaining tenants. There was only one, and that complaining tenant left. Number two, if you're going to argue that it might be applicable to a future tenant, the PAR determination doesn't make that determination. Three, even if you want to say some future tenant, this may impact some future tenant, the DHCR has also made it very clear that if a tenant doesn't sign the complaint, the remedy for the complaint, that being a rent reduction, is not applicable. And in the cases we cited, Wahid and Zushin and the others, all those tenants would have left and certainly would have impacted upon some future tenant, but it did not. You will note that the DHCR does not cite a single case in which a tenant has vacated either at the PAR level or at the rent administrator level and still found the order to be valid.
Thank you.
Good afternoon, Your Honors.
Good
My name is
afternoon.
Anita Shah, staff attorney at Respondent DHCR, Division of Housing and Community Renewal.
Would you address counsel's interpretation of the cases Zushin and Wahid? Are those cases, as he said, both cases where the tenant had vacated after the complaint was filed? Or did the
Not
tenant
Zushin,
vacate
not
before?
Zushin, the tenant's PAR was dismissed because the records show that tenant vacated before filing the PAR, and the tenant actually confirmed it. So I would say the distinction is in every case, the tenant gets to respond to the allegation that they have vacated.
And what about
In this
Wahid?
case, Wahid, tenant's PAR dismissed because inspector found that T vacated and T did not dispute it. So again, the tenant was informed and did not dispute DHCR's findings while their PAR was going on, the tenant's PAR was going on.
The question is, did they vacate before they made the complaint or after?
This is not even a complaint. This is the PAR level where the rent administrator actually ruled against the tenant. So the tenant filed a PAR, and then during the proceeding, inspector happened to find out that the tenant had moved away. Tenant was given a chance to respond, and they did not respond. So it was, so that there's a chance there for the tenant to respond, for the fact finder to find out exactly what happened. Here, the owner did not appear at all before the rent administrator. So only after it's been correctly ruled, based on the evidence before the rent administrator, then they came back in PAR and said, oh, by the way, she moved out here and here. Well, by then, there's no way to really confirm that the tenant doesn't get to respond. Maybe the tenant moved away, but maybe it's after the rent administrator's order was already issued. There's no telling that. And that's why it had to be done before the rent administrator, before the fact finder. And that's why the statute says that on par, the commissioner actually cannot consider facts and evidence that were not before the rent administrator. So that is my response, DHCR's position on that. And also, okay, and another thing I would like to address is that there is no basis for appellant's assertion that it is the tenant and the rent administrator's responsibility as an initial matter to unilaterally rule out the 4-year de minimis claim through either supplement form RA-84-2 or through inspection or otherwise. On the contrary, Rent Stabilization Code 2523.4F provides that the 4-year de minimis claim only applies to disputed services, and that even then it is within DHCR's discretion whether to consider such a claim. In Blue Star Properties, Inc. v. DHCR, this court affirmed that to apply the 4-year de minimis presumption to undisputed service would go against the legislative intent behind the RSC by allowing an owner to agree to restore services, then deliberately delay the action for 4 years in order to eventually not have to provide the service. And since the appellant did not appear before the RA to dispute tenant's allegations, the 4-year de minimis claim does not apply. Unless Your Honors have any questions, I shall rest here.
Thank you.
Thank you.
Your Honors, I'd like to directly answer the question that was addressed to my colleague, specifically in the Zushin and the Wahid cases, where the tenants in occupancy at the time they filed the complaint and later vacated. If you look at the Zushin case, it specifically says, the commission notes that the record of proceeding as confirmed by tenants indicated that the tenant was no more in occupancy of the subject apartment, meaning it was in occupancy when it commenced and later vacated. And as a result of that, the DHCR, excuse me?
How does saying the tenant was no more in occupancy establish that they were in occupancy at the time of the complaint?
The way I'm reading this, the commissioner notes that the record of proceeding as confirmed by tenants indicates that the tenant was no more in occupancy, and this is a par decision, meaning at the rent administrator level, the tenant would have had to have been in occupancy in order to file the complaint. It then says at the par level, it's no more in occupancy, and therefore we do not have jurisdiction to render a determination. In Wahid, it's even clearer, because they say, based on the tenant's contentions in this proceeding, the commissioner requested a reinspection. However, the agency's inspection indicates the tenant had moved out of the subject apartment. Again, at the rent administrator level, the tenant was in possession. It then left. And this makes perfect sense, Justice Gesmer, because the only remedy that you can provide a tenant filing a complaint on a rent services is a reduction in rent. That has absolutely no application to a tenant who once departed. And if you want to say, oh, but what about perhaps a future tenant? Specifically, like in these cases where you have storage uses and laundry uses, that affects the whole building. Why wouldn't they get the benefit of it? If you look at the HGW Realty case, that was a building-wide rent reduction complaint. A tenant sought to get a rent reduction, although it didn't file the complaint. The DHCR denied it, saying, only those rent-stabilized tenants who sign a complaint of decreased services may receive a rent reduction based on finding of a reduction of building-wide services. You just don't get the remedy if you vacate it. And to the extent the DHCR wants to take a contrary position, then you had to set forth in your decision, here's why we're taking a contrary position. Here's a case in which we found that even if you leave in the middle, we still find that there's jurisdiction. And absent that, if you do not adhere to your precedents, the courts have continually said that in and of itself mandates a finding of arbitrary and capriciousness. Thank you.
Thank you both. Burson Properties versus Nomura Credit.
May it please the court, David Tennant on behalf of the appellant, Burson Properties LLC. The summary judgment motion court stepped out of its role as issue spotter and stepped right into the middle of issue determination, most significantly with respect to the key factual contentions regarding the lender's bad faith. The core factual contention is that Nomura, the lender, stonewalled for 6 weeks the efforts of Burson, the borrower, to negotiate a replacement interest rate cap. Nomura absolutely refused to negotiate, even though it was under a mutual obligation to approve the strike price and the entity supplying the cap.
Counsel, if, as you say in your brief, that everybody assumed the strike price would be a positive number, why wasn't that assumption placed explicitly into the contract?
Well, I think the answer is that the strike price formula was believed to be suitable for almost all circumstances, and that there wasn't going to be a strike price that was negative, because a negative strike price is something that there's no market for obtaining a interest rate cap that's settled on a negative strike price.
There's no market, or is simply more expensive?
No, there's actually no market for a negative strike price. There's what I think, Your Honor, may be...
You could have raised the strike point. They make this point, that you could have raised the strike point by putting more money in the debt service reserve account.
Right, Your Honor, and I think that's an important point here with respect to what it means to actually put money into the DSRA. And it's what would have taken to turn this negative into a positive was $4 million of additional equity that the record shows there's at least a triable issue of fact as to whether Burson Properties had the wherewithal to make that kind of contribution. More specifically, with respect to the DSRA, the record shows that no one at the time, we're going back quite some number of years now, no one at the time, including Nomura, ever said, oh, this is something that you should do in order to change the strike price from a negative to a positive. Rather, it was the position of the parties at the time to negotiate a practical, pragmatic workaround that would then get the parties to a position where there was a commercially reasonable interest rate cap.
It seems to me that if you're arguing that we should find that it's not commercially reasonable, then we only get to that if we find that there's an ambiguity in the contract. And I feel like I'm a broken record on that issue today. But where is the ambiguity in the contract?
The ambiguity in the contract, what we're saying is with respect to the core issue of a bad faith breach of contract is that there is a mutual obligation. It's in 2.2.7A1 and A2, which spells out the mutual obligation of the parties to obtain a strike price and an entity supplying the interest rate cap that's acceptable to Nomura. And so what we're saying is that there are other aspects of the agreement that are ambiguous, and with respect to 2.1.9C, and specifically with respect to how there's a letter request, lowercase, uppercase loan advance, uppercase draw request, and we say with respect to those issues that Nomura is conflating the three of those, and actually there's ambiguity with respect to how those positions are supposed to be reconciled. But there's no core issue about ambiguity that requires a finding of ambiguity before determining that there's a bad faith breach of contract.
Anything further, counsel?
Unless the court has questions.
Okay, thank you.
Reserved for rebuttal.
Yes.
May it please the court, Richard Edlin, Greenberg Traurig for Nomura Credit. Your Honors, the decision appealed from is virtually a primer on the application of New York law to an uncontested factual scenario. And the only thing that was in dispute were the unavailing arguments that were made by our opponents. So with respect to the strike price issue which was raised, the simple fact of the matter is that the IRCA was insurance credit for Nomura. In year 2, because there was absolutely nothing done of any kind by Burson to re-tenant or generate income from this mall, in year 2, the strike price was negative. There's absolutely nothing in the contract that contemplates anything differently. It's just math. Math can come out to be negative, math can come out to be positive, depending on the inputs to that math.
And if I may, you indicated that in your brief, with respect that this strike price was a mathematical certainty that would arise whenever the borrower's financial condition was so poor that it could not pay the 1.75 percentage in the annual debt service on the existing borrowing.
Your Honor, it's exactly correct. And the simple fact of the matter is that there was a mechanism put into the contract to address the very issue, a mechanism that was referred to by Burson at the outset of this, when they, you'll see it in the record, where they discussed putting $2 million into the debt service reserve. In year 2, because they generated no income, there was a negative strike price, and Nomura agreed to use LIBOR as the reference point for the strike price. The only thing that changed in year 3 was that, having nothing to do with any of the parties, interest rates moved. And although there is nothing in the record that demonstrates one way or the other whether they had done any analysis as to whether they could afford it or not, when I asked Mr. Condor, who is the principal of Burson, whether there were $2 or $4 million available to deal with the IRCA issue, to deal with the debt service reserve account, he said they had it. That's at page 23 on the last 2 lines of our brief, Your Honors. So the question here, and the only arguments that they raised, was they thought it was too expensive. And what the motion court below, applying straightforward New York law to this issue, is it just doesn't matter. Contract compliance is not up to one party to decide whether they think it's a little too expensive to comply with. The law is very clear on this. It just doesn't matter. But as a factual matter, Mr. Condor, on behalf of Burson, said they had millions of dollars to deal with that issue. Now, Your Honors, with respect to the loan requests, I'm sure that you know the record. They were defective in all ways. And with respect to any of the other issues, unless there are questions, Your Honor, we'd be very content to rely on our papers and the decision below.
Thank you.
Thank you.
Just briefly, with respect to the DSRA and my colleague's suggestion that there was actually $2 million put into it, there was a reserve interest account that was essentially pledged against it. There was actually not an equity contribution. There was not actual money out of pocket, and Nomura knew that. So they were accepting a set of circumstances where the DSRA didn't actually have funds in it. And so they had a practice of accepting less than what was going to technically get the account to be positive. Mr. Edlin suggested that the only thing that changed was the interest rate. Well, what fundamentally changed was Nomura's whole attitude about working around the interest rate cap problem and coming up with a solution. The year before, it was a negotiated, consensual agreement that came to a commercially reasonable interest rate cap. And what changed, certainly the interest rates changed, but what dramatically changed was Nomura's position that they could just unilaterally demand the cap be set at the then prevailing LIBOR without regard to its commercial reasonableness and without regard to what its costs were in prior years.
Wasn't that the same agreement that you got the year before? The pending LIBOR rate during 2008 is exactly what you got in 2009. The difference being that the rate was different now in 2009.
Well, the rate is different, but it's also how the parties reached an agreement or didn't reach an agreement. There were other ways to potentially come up with an interest rate cap in 2009, but Nomura had taken the position that this was a flat edict that was non-negotiable, and this was coming from the edict from Tokyo that they were to protect their equity, their liquidity at any cost. And that's what the record shows, is that they actually protected their own liquidity at any cost, including sacrificing this project.
Thank you. Thank you both.
Thank you. Thank you, too.
Good to see you.